Good afternoon, everyone. Thanks for joining us today. So I am Kendra Hoffman. I'm the Regional HR Director at PuzzleHR, and I'm joined with Deanna Hayes as well from Ogletree Deakins. So thank you so much for joining us today, and thank you for joining us as well, Deanna, as we talk through some of our favorite HR topics, so HR compliance. Deanna and I had the opportunity to present around 4 months ago. I believe it was June, so we did the spring symposium as well. And at that time, a lot of the topics that we are going to be covering today were up and coming, and they're happening in July and August and this fall. And so we have a lot of updates from what we presented on earlier this year. And so some of the details might be a little bit what you've heard in the past, but now we have current updates of where they stand today. So want to kind of add that in. I will be manning the question and answer section. So please, if you have questions throughout, please add those to the chat or the question and answer, and I will address those either at the end. We'll definitely have some time, or throughout the presentation today. So that being said, thank you again for joining us, and I will hand it over to Deanna.
Thank you, Kendra, and thanks again to everyone for being with us today. And as you may have heard, there are a whole lot of updates. I feel like this world is constantly changing when it comes to employment law and everything that HR professionals have to keep up with. So we will try to hit the highlights for you and what we're seeing clients ask a lot of questions about. But as Kendra said, we want to make this meaningful for you. So if you have other questions that we don't address, please feel free to ask those in the chat. So first, when it comes to non-competes, this has gotten a lot of attention over the past 6 months, I would say, when it comes to the FTC's rule banning non-competes. It certainly got a lot of media attention, which is what the FTC wanted. Back in April, the agency adopted a rule that would have essentially banned all forms of non-competes. There would have been a limited grandfathering exception for senior executives who were already employed by the company and were making over $151,000 and change, which is a pretty high salary amount there. Then we had cases challenging this rule in the great state of Texas, which is usually the forum of choice for challenging government action because Texas has a very conservative group of judges in its district. And on August 20th, the court actually held this to be unlawful, and it had a nationwide impact. So currently this rule is blocked. At first, the court had entered a preliminary injunction that would have only applied to the parties in the case, but that is now in effect nationwide. So what is going to happen next? So the FTC has until October 19th to decide whether or not to appeal this ruling. So the rule is not totally dead at this point, but a lot of the brilliant minds in my industry think that it is not going to come back in this form because the agency has overstepped its rulemaking authority, particularly also with the Supreme Court case that you may have heard about called Brightline, that basically ended Chevron deference. Chevron was the prior case that allowed these government agencies a wide range of discretion when interpreting and implementing rules like this one. And the Brightline case said, no, perhaps they have had too much power in the past and they're overstepping the bounds of their authority. So with that being said, just be mindful that unfortunately doesn't mean that you can have any kind of non-compete everywhere that your business would like. States have gotten into this game when it comes to restricting what employers can have in a non-compete agreement. Some states outright prohibit non-compete agreements, California, Minnesota, Nebraska, and Oklahoma, to name a few. Some states say that continued employment or the start of an employment relationship is enough to make an agreement binding. Other states say, no, you have to give some other consideration beyond that to make these binding. Some states say you can only have them for employees that make a minimum salary amount. And some states say they're only valid if you present them within a certain amount of time before the employee is hired, right? So a lot of different things swirling around that you should be mindful of when it comes to non-competes. And also just remembering, what does that mean, right? Because you may have restrictive covenants that don't come under this scrutiny, right? So typically there are three buckets when I'm talking with clients about information they want to protect or relationships that they want to protect. One of those is just a pure non-disclosure of confidential information and trade secrets. That is going to be okay, even in these states that prohibit a non-compete. Then the next level is non-solicitation. So typically non-solicitation of your current employees to leave you to go and work for a competitor, or non-solicitation of your clients, customers, patients, or prospects, right? And then beyond that, a true non-competition provision would mean you cannot go and work for a competitor within a certain geographical radius for a certain amount of time, even if you don't do those other two things, which would be soliciting people or sharing confidential information. And Kendra, I bet you're getting a lot of questions in this space too. Any thoughts to share?
Yeah, this was a hot topic a month ago, and really was waiting to see what was going to happen. Knew that they may have overturned it. So this is still a conversation that we're having. It's still, we're understanding it, learning it, being able to kind of address certain states and what's prohibited within each state versus federally. So it has been a hot topic in HR. Thankfully, we have more direction now than we did last month. So.
Absolutely. So the other issue that I feel like has gotten a ton of attention is the DOL overtime rule. And we had mentioned this during our prior presentation. So we'll really focus on, okay, where are we now and what's the next step? So step one became effective on July 1st, which is raising the salary minimum for the white collar exemptions. So that went up to 43,000 and change, and it's set to increase again on January 1st to $58,656. So just because you've kind of done what you needed to do to comply with step one, don't forget about step two. There are legal challenges right now to this rule. So we're not 100% sure whether it's going to go forward. A lot of folks felt like step one would stand, and it has so far, but it's a pretty drastic increase in a short amount of time to go from 43,000 to 58,000 from July to January. So most people are saying if we are going to see a successful challenge, it's going to be now or as we near January 1st. Does the agency really have the ability to set this salary amount so high and increase it so quickly in a short amount of time? Another piece that's ripe for challenge is if this goes forward, the threshold would automatically increase every 3 years based on wage and census data, right? So that's another question of, can the agency do that and build in this automatic increase? So it's something to continue watching. Just like you did with step one, you want to identify, okay, do we have folks that would lose the exempt status because they're not at that $58,000 and change? And identify what you would do if this does go forward on January 1. Are we going to raise pay, or are we going to potentially make these individuals non-exempt going forward? Those are the main two choices. One question that I get a lot is, okay, well, we have a group of employees in the same job title, and half of them are going to be fine. They're going to be above that $58,000 minimum, but the other half are going to be below. How do we handle that? Be very cautious about classifying employees in the same job title in different ways as exempt and non-exempt, right? So you may even decide, well, is there some kind of differentiator that we can logically apply and maybe split that job into two? So maybe you had an analyst and a senior analyst, and they all meet the job duties test, of course. The only difference would be the salary. And so we're going to go ahead and keep those making more in that senior title because they've got more years of experience, they've got more time in the job, and we're going to make the other group non-exempt, but they would have the potential for progression in the future. I've seen some clients take that approach. Kendra, I don't know if you've seen any questions in this arena as well. I know it's a hot topic.
Yeah. So we've had a couple different scenarios, and it is that, we have a large group of employees that are sitting in this job and ultimately half make under that threshold, half make over. And so how do we want to handle that? So we've worked through that with our clients. We've also really reevaluated job descriptions. Are there duties that should be moved to someone else? So the position ultimately is not meeting the classifications of being exempt, and so removing and modifying ultimately the tasks that the employee is doing, which then and updating their job description to reflect that as well. And then also, I think it's a very two different approaches to this. There is the compensation piece, and there is also the exemption testing piece. So a lot of what we spent time with is helping our clients understand that it is two separate things, and to differentiate them versus putting them in one bucket. So now we've done the part of identifying if the position is going to be and should be exempt or not. So now it does a salary meet as well, and that's what we'll continue to do when we come into this winter with that next level step as well, if that does move forward. So was something that we worked through heavily. We have also, worked with clients that said, I don't actually want to do either. So what is my risk to do neither and just be non-compliant here? So we have worked through those as well, just understanding what the risk is if you are not going to adjust the salary, and if you're not going to adjust what the job duties are as well, what kind of risk they may pose. So yeah, very, very hot topic this summer. When we were doing the symposium last time, I know we were anticipating what is going to happen, and so now we know. So now it's just planning for this winter as well. And then we did get a question on what is HCE, and that is a highly compensated employee. So that acronym was used in the last slide, so I just wanted to identify that as well.
Yes, absolutely. And so if you're using that exemption, the threshold for that also has increased, and it'll increase again on January 1st. So it increased to $132,000, almost $133,000, and then it's going to go to $151,164, which was also the same number that they used in the FTC rule for senior executives. And so interesting tie-in there. A couple of other points on this, I would say, this is the perfect time to do your own wage and hour audit, or to work with Puzzle or outside legal counsel on that and identify, have we gotten these exemptions right? Do they meet the job duties test? Because if not, you can fix it now and blame the government, right? Like the government rules are changing. So unfortunately, we're going to have to change your classification, and it can help cover up any potential mistakes that might have been made in the classification in the first place. Because we all know that jobs change over time, right? And perhaps the person was truly exempt when the role started, but duties have gotten moved around. And now that's no longer the case. So this is a good opportunity to address those pieces. And also just remembering, it didn't change with this rule. The regulations have been in place, but up to 10% of the salary minimum can come from incentive pay, like bonuses and commissions, right? So if you have some employees that are almost there and they're getting that incentive pay, they might be okay. You just have to track it. And if for some reason they're not going to hit the minimum at the end of the year, make a catch-up payment so that they will be at that salary minimum.
And then it is a lot of what we hear is, the administrative burden on moving someone that was exempt, that, if you just paid them their standard salary, now I had to take time cards. And so something that we at Puzzle had worked with our clients on are, do they have the right system in place to be able to capture, clocking in and out? Are we still on the paper process of, tracking time, and can we move that electronic? So really it's not becoming an admin burden or additional payroll burden. If they do have to have a large group of employees, or even one employee, move from that salaried to that hourly position, because that obviously does add more work on the back end when processing payroll. So we've been able to kind of work with our clients on what is the easiest way to make sure that you're paying your employees appropriately.
Absolutely. I know you all do great work too in helping clients with the messaging as well, because sometimes it can be a hit to employee morale, because I don't know why, but historically it seems like exempt status has equated to a more professional position or a higher level position, when sometimes that's not the case at all. But it's just making sure that employees understand that and that you value them.
Oh, all right, and then we got one more question before we move on, and this question actually got to work with a client on this year as well, so I'd love Deanna's expertise on it. But can the incentive pay, let's say a bonus, be paid outside of payroll? And I actually, with that question, worked with that in regards to a client that pays a 1099 employee as well. So they have two different lines of work that this employee does, and can we count the 1099? And you cannot.
Right.
And so I think that answers that question as well. And that was a topic that we did review with a couple of our clients this year. But can the pay be outside of payroll? It cannot.
Yes, great point. It could be on a different schedule as long as it's still payroll, like you said, Kendra. So maybe it's a quarterly bonus and it's not paid biweekly like their regular salary is, that's fine. But certainly, yes, if it was 1099, that would not count. You're absolutely correct. And just some other trends to be aware of, because we know we have everyone on the line and you may be all around the country, that this can differ by state law as well. And it's really important to get the basic wage and hour pieces correct, because this is still kind of the #1 area for employment litigation that we see across the country and is really the biggest risk for employers of all sizes. One, minimum wage and overtime. So just make sure that you're aware that 31 states, so the majority of states, have a minimum wage that is higher than the federal minimum wage. Some states, like California, also have different overtime requirements. So if an employee works over 8 hours in a day, that employee would be eligible for overtime. So it's not just the flat 40 hours in a week like the federal standard. So be aware of that. And we're also seeing a new trend where some states are setting their own salary minimums for exemptions. They were tired of waiting on the Department of Labor to get it right, and they've done it themselves. So if you're in Alaska, California, Colorado, New York, or Washington, be aware that there are some specific requirements there. So paid sick leave, just wanted to quickly mention this. I know this is something that is a particular thorn in the side of a lot of HR professionals because it's really difficult to keep up with. This is an area that has changed quite rapidly. So we gave you at a glance here a map so you can see the states that require private employers to provide paid leave that can be used for any reason. Those are in dark purple. Also, the light purple would be states that require private employers to provide paid sick leave that can be used for illness and other statutory defined reasons. Domestic violence is typically one of them that can come up fairly regularly. And then if it's white, that state doesn't have any particular law when it comes to paid sick leave. You can see more and more jurisdictions do have this requirement. And just to highlight what's new, I mean, we could spend 2 hours just talking about the requirements of all those different states. So I wanted to kind of focus on what has changed very recently. There have been increases in the amount of required hours that employers have to provide, expanded reasons to be able to take that type of leave, new notice requirements or posting requirements. And we've listed the states out for you so you can see if it applies to you. And there are some family care acts that have been made permanent or reintroduced. So be aware of that. And then in Minnesota, the Earned Sick and Safe Time law that was in place has been repealed and replaced with an entirely new law. So make sure you're aware of that if you're in that jurisdiction. And when it comes to paid sick leave, I mean, I get asked questions all the time about the best way to handle it. And it truly is a business decision. But I would say the most common practices are, one, address it in an addendum to the handbook, or maybe even keep your paid sick leave policy separate from your handbook and have a different one for each of these jurisdictions that is minimally compliant. So you're doing the least possible to be compliant in each of those jurisdictions, which can be beneficial from a cost perspective. But I have some clients that say administratively, we just don't have the bandwidth to handle 15 different paid sick leave policies. We need it to be more simplified for our HR team. And in that case, you can either go with the most generous jurisdiction that you're in and apply it across the board, which isn't attractive to some people for obvious reasons and the cost. Or you can maybe even have a regional approach. So maybe you have 3 policies that are that meet the majority of the requirements in certain regions. So you don't have 15 different ones, you have 2 or 3. So that's another option that I've seen clients turning to. Kendra, I don't know if you have any thoughts about paid sick leave.
Yeah, it's a constant changing process that we are keeping up to speed on. We have a LOA team here at Puzzle that really make sure that we're compliant with all of our clients that have leave of absence services and are able to be experts in each of those states. So I'm happy to have that team internal to give our clients that expertise.
Great. Okay, so moving on to equal employment opportunity and some updates that we're seeing there. So the biggest thing I would say would be expanded requirements for accommodations, and these come in different buckets. One is the Pregnant Worker Fairness Act, or PWFA. This act has gotten a lot of attention. The EEOC is very focused on enforcing the requirements of this new act, and they've issued guidance documents, which you can find easily on the EEOC website. So if you're not sure what all the parameters of the new law would be, you can look at the website and get some guidance there. Basically, in a nutshell, it's no longer does this pregnant employee have a medical condition that would render them disabled and entitled to an accommodation under the ADA, right? So now the disability piece has been taken out of it. And if there's some accommodation that's purely related to the pregnancy, childbirth, or other related conditions, it is something that might have to be accommodated. Another thing that makes this different from the ADA is if someone cannot perform all the essential functions of the job, but that's only temporary, you may have to accommodate them anyway. That may not be enough to show an undue hardship like it is under the ADA. So that's something to be aware of. Also, the ability to request documentation is more limited than in the ADA interactive process. And what I mean by that is if you have one medical questionnaire that you ask employees to fill out when they ask for an accommodation, it's probably got a lot of questions that aren't relevant to this PWFA, like does this person have a disabling medical condition, information that would be totally unrelated, or if it's morning sickness, right? There may not be any documentation of that, but that's a known symptom of pregnancy, particularly in certain stages of pregnancy. Or if a pregnant employee comes to you and says, I need a larger uniform, that's a situation where you wouldn't require them to get a doctor's note to prove that they need a larger uniform because that's an obvious need associated with pregnancy. And finally, another thing to point out here would be that reproductive choices are specifically covered. And that's something that is new, right? So even if you had a male employee that needs time off because the employee wants to get a vasectomy, that could be covered, even though that employee is not pregnant, because that is a reproductive choice and a related condition to pregnancy and childbirth. And the PWFA applies if you have 15 or more employees. So it's the same standard as Title VII. We also have the PUMP Act, which would require employers to provide space for nursing mothers to express milk in the workplace. That's not a bathroom. And that's been in place, but there is an undue hardship component if you have fewer than 50 employees. So this makes that a little bit trickier with the PWFA because that applies when you have 15. So if the accommodation needed is a place to pump, you might have to do that as an accommodation under the PWFA, and the PUMP Act might not be controlling. So just be mindful of that. And then lastly, we had a Supreme Court case, Groff versus DeJoy, which basically changed the legal analysis when it comes to accommodations for sincerely held religious beliefs. In the past, that has been a lesser standard than disabilities under the ADA. It's been a de minimis standard. So anything more that would be than a minimal cost would be an undue hardship. The Supreme Court said, no, that is wrong. It's incorrect. That is not enough. unfortunately, they didn't tell us what is enough. So it's something that's ripe for more litigation. And as a best practice and a conservative approach, employers might want to take it and view it almost like a disability accommodation, right? So be able to show some significant financial hardship or operational hardship before you deny that request, and making sure, again, that you're making an effort to go through an interactive process with the employee when it comes to those. One quick example, in the past, if someone wanted time off to attend religious services or for religious observances, it was enough to say, okay, if you can find another employee to take your shift, we will allow you to do that. That is no longer going to be enough, right? The employer is going to have to be the one making the effort to see if someone else can cover that shift. So what does this mean? A couple of things. One, if you have a handbook policy that addresses accommodations, I've often seen those policies called ADA policy or disabilities policy. So think about either reframing that or adding 2 additional policies that address pregnancy, childbirth, and related conditions, and sincerely held religious beliefs, so that you're covering all 3 of these buckets and not just limiting it to employees with disabilities. 2, again, you probably don't want to have the same accommodation form for all 3, because the documentation is going to be different depending on what the employee is asking for. And the EEOC is taking the position that, again, you shouldn't be asking for documentation that is unnecessary. So if it's pregnancy, we shouldn't be asking for documentation of things that are obvious. If it's a religious belief, we shouldn't be asking employees to attach documentation from a spiritual leader across the board. There should be some reason that you have to doubt the sincerity of the religious belief, and then you can ask for more information, but that shouldn't just be generally part of the accommodation form. However, that is more common when it's just a medical condition or a disability that we're dealing with, because those are typically less obvious than with pregnancy. And then lastly, think about how are you going to handle these requests when they come in? Who's going to review them? Who's going to decide whether they're granted? Who's going to document the interactive process? And train your first level supervisors to know who that person is. So when they hear about this, they know I'm not supposed to make this decision on my own. I'm supposed to direct it to the person who's trained to handle this. Kendra, any thoughts on this as far as accommodations?
Yeah, accommodations are tough, because I can say that no requests are the same. So every single one, you do have to go in and really say, all right, let's start from what we know, what questions we need to gather to make that best decision for this employee. So I've seen a lot, we've worked through a lot. Every single one has to be evaluated on a case-by-case basis, just based on what accommodation is ultimately needed. So it is an area that is tricky. If you haven't been exposed and aren't trained to it, it's something that, you know, what stance and how do you review it takes a very you know, strategic approach on how you want to handle these, and then knowing that you have that person that can handle them going forward as you do get them in is very important as well. So they are handled fairly and equally by the same group that's reviewing them.
Absolutely. And sometimes we have what I like to call the Bermuda Triangle of workplace issues, where it starts as a workers' comp injury and the person takes FMLA leave, and then they're not ready to come back and they need something else as an accommodation, whether it's more leave or light duty. So sometimes you have all of these different laws swirling around together and you can't make a decision in isolation.
Yeah, and I think the most important thing that I need to remind our clients, and then also anyone that's reviewing these, you don't have to always say yes. So when it's presented to you, I've seen individuals make quick yes responses without fully understanding what they're agreeing to or what the accommodation is, without getting and gathering more questions and getting more documentation to possibly support. But I think that is the one thing that I've learned, is that you can have some time, make sure you fully understand, ask the questions, and don't immediately say yes until you're very solid in what you're agreeing to.
Excellent. Excellent point. Absolutely. And the employee is not entitled to the accommodation of their choice, right? Either. Like if there's something else that's a reasonable alternative and what they're asking for is not reasonable, then you can suggest or mandate an alternate accommodation there. And another strategy that I've sometimes seen employed is if you're not sure how it's going to work, you can temporarily grant it. You can say, we're going to grant this for a 30-day period, and then we're going to evaluate whether it's having an undue hardship on the business operation so that it's clear from the beginning that you're not agreeing to do this indefinitely. So just some examples to share of kind of this stuff in action that are very recent from the EEOC. The EEOC has a newsroom on its website. They are very excited to talk about all their enforcement activities and all of the money that they are recovering for employees. Here's one that was very recent from September 11th, where a Tampa pest control company agreed to conciliation with the EEOC. In the charge of discrimination, the employee said that the employer fired her after she requested a reasonable accommodation to attend monthly medical appointments for her pregnancy. So again, that's something that's limited in time. It's once a month and it's temporary because pregnancy in and of itself is a temporary condition, right? So it's something that the EEOC has focused on. In that case, the employer paid $47,000 in damages, which is a lot if you're a small business. And even if that number doesn't sound a lot, they also had to appoint an EEO coordinator, revise their policies to specifically include reasonable accommodations under the Pregnant Worker Fairness Act, have to train both management and non-management employees, and then provide quarterly reporting to the EEOC that they're doing the training and what type of accommodation request they're getting, right? So that's a lot more money that company had to spend to get into compliance. And the EEOC is still watching them to see if they're doing the things they said they would be doing. So it certainly can be a big deal when you get into one of these issues with the EEOC. Another very recent one involving pregnancy, the EEOC has sued an employer who denied a pregnant employee's accommodation request to transfer to a role that did not require lying on her stomach and subjected her to an unlawful medical inquiry. So again, just another example of we can't be asking for medical documentation of things that are obviously related to pregnancy.
Based on that, Deanna, there are a couple questions.
Sure.
And so one of the questions is, what about a return to work note for a pregnancy? Can we still ask for that?
So I guess the answer is it would depend, right? So if the employee had complications during the pregnancy, had a C-section, there was time that was necessary to physically recover from the pregnancy beyond a regular childbirth, then yes, you would have a reason to ask for that information because you had reason to believe that the employee couldn't do their job and would have difficulty performing their job in the near future.
And then one other question that came in, and it's with the PWFA. Do employers have to accommodate fertility treatments?
So that's a very good question. So potentially yes, unless it would be an undue hardship on the business, but that would be a covered reason potentially for asking for an accommodation under the Act. Great question. All right, some other examples, and these are the more high dollar examples just to show you how expensive these things can get. And again, they're all within the past few months. There was a furniture retailer who agreed to pay $110,000 to settle a religious discrimination lawsuit associated with the denial of an accommodation to not receive the COVID vaccine. And things move very slowly when it comes to litigation. So we're just now starting to see the outcome of some of these COVID cases. But I will share too, in one of those cases that I handled for an employer, the EEOC was adamant that they should not have asked every employee to attach supporting documentation from a spiritual leader to the exemption request for the vaccine. And so that's something that the agency has been focused on there. Another one, very high dollar, a staffing agency agreed to pay $875,000 to settle an EEOC sex discrimination lawsuit. And that was related to hiring and the placement in the most desirable staffing assignments for that agency. And then a huge one, there was a laundry facility that agreed to pay $2.2 million and provide extensive injunctive relief in a hiring discrimination lawsuit for race, sex, and national origin. So these cases can get really expensive, particularly when you're dealing with something that impacts more than one employee. So the more employees that are affected or candidates that are affected, the riskier the decision is. So that's why it's very important to review your policies on a regular basis, your hiring and selection processes, to make sure that you're compliant as these laws change. And Kendra, any thoughts to share there?
No, I always think the EEOC, kind of what has gone through is always very interesting. The EEOC does throw out cases that they receive, so I think that's also good to note that not everything that they receive they go after. I mean, some of them they do their own investigation and say, hey, we're not going to go further on this. So the EEOC, is an area where we need to trust them and work with them too if a claim does come through, to help understand kind of what is the claim, what can we mediate in really review right now until we get further down the road to some of these big claims as well. So the EEOC is one of those areas that we can coach and guide our clients through, and really hope that we're doing all the right things to mitigate some of these.
Absolutely. And for those of you who have never been through the process of a charge of discrimination, essentially an employee has to file that with the EEOC or the equivalent state agency before they are allowed to sue the company in court. So it's kind of like an administrative gatekeeper to those claims. And as Kendra said, they really do find that the majority of these charges are not founded. So if you're cooperative, you meet their deadlines or ask for extensions and then meet those deadlines, and you provide them with the information that they need, you are in a good position to hopefully deal with that issue before it does go to full-blown litigation in court. So also in the realm of the EEOC, just wanted to highlight this as well. They have updated their guidance on workplace harassment for the first time since 1999. So that's been a long time coming for this update. It has brought them back into the current times with respect to online misconduct. So they've made it very clear. I think in the past, the focus has been on, okay, well, what happens if you have a group of coworkers who are not at work, they're not on working time, they just all get together and meet at a bar, and somebody says something that's inappropriate or makes an inappropriate advance and then reports that to HR. Does the company have to worry about that because it didn't happen at work? The answer is yes, you do, unfortunately, because now it has been brought to the company's attention. These individuals are going to have to be interacting with each other in the workplace, so it does make the issue relevant. And this guidance has made it clear that even if this happens online, if it comes to HR's attention or the company's attention, it is something that should be addressed as a potential violation of policy. So whether that's through social media or otherwise, it's something that should be addressed and contemplated. And again, another reason to educate your first level supervisors that if they hear about this, that they should elevate it to HR, to the appropriate person in the organization who can decide how to properly handle that issue. This guidance, like the PWFA, made it clear that reproductive choices and abortion would be covered. I think particularly important as we are at the tail end here of an election year. There's a lot of talk in the political world about reproductive choices. Of course, hopefully we can separate the two, but just know that if there is talk about abortion, that could be a basis for harassment as well. And I put the link in there to the guidance. If you're curious and you want to read it, it's available to you. And one of the things that I think is really helpful is it also explains what the EEOC says that policies should include when it comes to effectively preventing workplace harassment. Of course, identifying what it is and then having a workable complaint reporting process. And that's probably the most important piece of this, is having a way for employees to report concerns, and then hopefully the employer can effectively resolve those concerns and would have a defense if the employee later claims harassment because the employer effectively remediated the issue, right? So when it comes to the complaint reporting process, one, make sure that there's a way to report it at any time. It doesn't mean you necessarily have to have a live person standing by a phone 24 hours a day, but is there an online reporting system? Is there an email? If there is a 24-hour shift in a warehouse, for example, is there somebody that can handle that at all times when employees are physically present in the workplace? And hopefully having more than one avenue for the employee to report, so that if the supervisor is the bad actor, they could go to somebody else to raise that concern if they're afraid of retaliation, that something bad is going to happen to them for complaining. And then making sure you have a mechanism to handle these complaints quickly and effectively, because the timing will become important in the decision about whether or not you effectively corrected the issue there. And I know that's something that Kendra helps out with a lot too, is investigations and making sure that things are appropriately handled. And just know that there are some states that require sexual harassment training on a regular basis, either at the time of hire and or annually. So if you're in one of these blue states, that applies to you. Even if you're not, it's certainly a best practice to train your employees and particularly your managers on your harassment prevention procedures and policies so that they understand what the requirements are. Okay, and looking at the world of workplace safety, I think we talked about some of these in the prior symposium that we did. So we wanted to, again, focus on what is new. So OSHA's proposed heat illness rule has been published in the Federal Register. That just happened a few weeks ago. And we're in the notice and comment period, which means that when an agency wants to make a new rule, it has to put a notice in the Federal Register that allows for interested parties and stakeholders to say what they want to say about the rule, whether or not they think it needs to be altered, whether it needs to be scrapped altogether. You're free to make whatever comments that you would like to make, and those are due on December 30th. So if you looked at this rule, if it's going to have a big impact on your business, you might consider filing a comment. It's really easy to do. I put a link in there so you can see the proposed rule, but this rule is massive in a nutshell. It basically would kick in at 80 degrees for indoors, and for outdoors, it would be a heat index of 80 degrees. And man, I can't wait for that in Florida. That is like a cold front in Florida, and I know in Texas and most of our southern states. So it's a very low bar when it comes to heat stress. And it would apply to employees that are working outside for 15 minutes in an hour period. So that covers a lot of people, not just traditional construction and landscaping, car dealerships, salespeople that are going to be outside. If you have a retail person that's holding a sign, if you've got somebody directing traffic, this could apply to a whole lot of people. And it's not just about giving them water. That's certainly part of it, but it's break time. It's making sure they have access to shade. It's training employees on the signs and symptoms of heat illness. It's having a plan for what to do if somebody does have an emergency event that's related to heat. And it has to be site specific to each of your locations. So this is another thing I could talk about for 2 hours alone, but since it does apply to such a wide range of industries and it has now officially been published in the Federal Register, we wanted to make sure it's on your radar. All right. And then lastly, we wanted to give you a quick update on the National Labor Relations Board and traditional labor. This is the general counsel for the NLRB, Abruzzo. She's very aggressive and has made no secret on the fact that the government wants to make it as easy as possible for employees to organize and to form or join a union. So why does that matter to you if you don't have a union in your workplace? we just wanted to quickly go over, okay, so who is covered by this National Labor Relations Act and what is it? So first of all, it doesn't just apply to workplaces where there is already a union in place. It is the right for employees to get together to bargain or to talk to their employer about their wages and other terms and conditions of employment. So this means your non-supervisory employees, hourly employees, have the right to talk about their wages. They have the right to talk about their boss treating them inappropriately. And all of this is protected activity. So we just want to be mindful of that because those are topics that come up all the time in the workplace. And they usually make executives not very happy, right? When people are sharing information about wages, when people are talking bad about their supervisors. But unfortunately, they do have a right to discuss those items in the workplace because it's called protected concerted activity. So what does that mean? It means I'm not just one bird on a wire griping individually because I don't like my pay. It's I don't think me and others are being treated appropriately. So it would be protected if an employee is seeking to better others or if they've been appointed as the spokesperson for more than one employee. And this can apply on social media as well, right? So if you have someone who's making comments and other employees are liking it, doesn't mean that you don't have any recourse there. It just means check in with Puzzle or your external legal counsel to make sure you're on solid ground before you discipline that employee. And because we know that we don't have a lot of workplaces anymore, thankfully, in my humble opinion, they're covered by labor unions. What applies to everybody? One, handbook rules. You probably have heard about this back in the Obama administration. The board was very aggressive about looking at handbook policies and saying they shouldn't prevent employees from doing this, from getting together, from talking about wages or other working conditions. So that's where we are now. It swung back the other way when we had a Republican administration. So this could change again with the election, but it's just something to watch. If you're using separation agreements for your employees, the board has also said those shouldn't have confidentiality and non-disparagement for your non-supervisors. So be aware of that. There is some language that you can use that is still appropriate. So again, if you're using those and you're not sure if they're compliant, work with Puzzle or your external legal counsel. And then non-compete agreement. So this is the other kind of federal arena where we've seen non-competes challenged for non-management employees. The board has taken the position that they shouldn't be used for employees that aren't supervisors because they typically don't actually have information that could harm the company. Doesn't mean we agree with the board at all, but just be aware that these things are out there. Now, what's the likelihood that you're actually going to end up in front of the NLRB, knocking on wood? Hopefully it's not very high, but anybody can file an unfair labor practice charge, just like anybody can file a charge of discrimination. So it's very easy. It's just that I don't think the general public knows as much about the board as they do about the EEOC. Any thoughts there, Kendra?
No, I that the NLRB is an area that I leave for you guys to lead us on. So
Sure.
Sure.
And then lastly, I just wanted to mention, because it's something new that we're seeing as a trend in many states, would be changes to child labor laws. So several states have relaxed restrictions when it comes to employing minors in the workplace, particularly for 16 and 17-year-olds. So we have a summary there, but some of these states have new required posters that all employers would have to put up. There's a whole host of states that have relaxed restrictions, just like my home state in Florida. So they basically, for 16 and 17-year-olds, have removed the requirements for breaks, have allowed them to work more hours, and then allow them to work more consecutive days per week, even when school is in session. Some of them have reduced the prohibited occupations. Like Florida now, you can actually work in construction as an apprentice as long as you have had OSHA 10 training and the person supervising you has had that safety training as well. So I know some companies are very against hiring minors. Some are very excited about the opportunity because it's really hard to find qualified people. And some of these individuals can be really great addition to the workplace. On the opposite side, there are some states that have implemented stronger protections for minors in the workplace. So changing those meal and rest periods to provide more breaks, more restrictions on work hours, more prohibited occupations, and even giving them anti-discrimination, anti-retaliation provisions. If they are complaining to an employer that they're not following the laws, they would have a recourse if they're retaliated against for that. So if it's something that you're interested in, just make sure that you're aware of any changes in that area. And I know we wanted to leave some time for questions. So if anyone else has any questions in our last kind of 5 to 7 minutes here, we're happy to take them.
Yes, no, thank you, Deanna. This is all great information that, you know, is always changing. So always appreciate your updates when you have them. So we do have a couple of questions in the chat. And so one is, can you talk about unlimited PTO policies being compliant with paid sick leave?
Yes, so unlimited PTO policies can be compliant with paid sick leave requirements. You just have to carefully track the time, how it's being used, and the reasons that you're letting people use it. Because although we say unlimited PTO, sometimes there are parameters set around when an employee can utilize unlimited PTO. So you want to be careful because it's not seamless when it comes to just saying, well, we don't have to worry about those paid sick leave laws because we have unlimited PTO. There are also payout requirements in certain states if an employee hasn't used accrued time. So that's another piece that you would want to be mindful of as well. And I know Puzzle and again, external legal counsel can help with that.
Yes, it's always, you know, pulling in, making sure that it's unlimited, but having the factors around it if it needs to be constrained at all as well, for that sick time as well. So that if someone goes out on leave, it's not, you have some parameters that you can play with as well. All right, and another question, can you ask for a return to work note from an FMLA for pregnancy?
Yes, yes. So you would just want to be able to tell them that from the outset of the FMLA leave that you're going to require a fitness for duty. And that's actually built into the FMLA regulations, which is nice. So those have not changed.
Great. Can employers run background check and drug screens on minors?
So yes, as long as that is allowed in the state where you're in general, as far as background screens. And a lot of states are silent on some of the parameters when it comes to employing minors, like Florida, for example. There's no requirement that a guardian sign that form or sign your handbook acknowledgement or sign your offer letter. However, it might be a best practice, right? Because from a PR perspective too, I know I have some nonprofit clients that are like primed for this, or retail clients that are primed to potentially employ minors. And what they don't want to do is end up on the local news with some parent kicking and screaming that their child is getting bad grades because they're working for this company and they didn't even know, right? So maybe it's asking the guardian or parent to sign an acknowledgement that they understand that the person is going to be working, these are the work hours, or these are the conditions of what would be required to go through the onboarding process or the interview process. And I think that's probably the way to go, just because that way you're not stepping into a mess because the parent or guardian isn't aware, even though that's not specifically required by law.
Great. And one additional one. Is discretionary PTO used during FMLA, or would the employee go unpaid?
So that's totally up to your policy, right? So typically we would recommend that the company consider having those run concurrently. And the reason for that being is once somebody has exhausted their FMLA, they wouldn't have an additional bucket of time to pull from so that they could be out for a really long period of time. But that is your choice. And I do know that some companies have different buckets of leave, and they do have some discretionary leave that doesn't run concurrently because they want them to have the extra time. So as long as your policies are clear, that would be up to the company.
All right, and here's a question. I don't know, again, if you have any thoughts off the top of your head, but would it be best practice if minors are employees to have all employees participate in additional training such as sexual harassment training, which is yes, but then the other part of the question is what other trainings, if any, would be beneficial for minors?
So, of course, I think any of the training that you would normally provide your employees on clocking in, clocking out, harassment, EEO, those are typically the biggest risk areas, and just by virtue of them being the most commonly filed claims. So I think that would be helpful to make sure that they understand what those requirements are. And then if you're in a state that does have restrictions on work hours and required break times, make sure your first level supervisors understand what those are so that they can make sure that those minors are complying with their required break times and work hours.
All right, that is all that we have for questions. So thank you everyone that submitted questions, all great questions, and makes us think as well. So I appreciate, Deanna, you joining us today. Deanna, we work with, again, very closely at Ogletree Deakins as our employment attorney partners. If you have questions, definitely reach out to PuzzleHR.
Thank you so much for having me. I appreciate it.